SAGE 888-971-7243. I am Larry Elder. We are ReliefFactor.com studio. I'm pretty sure she said he ought to be charged with manslaughter?
Yes, I think that the officer should be at least charged with
okay, he's been charged with 3 charges, including manslaughter. 2nd-degree murder, 3rd-degree murder, and 2nd-degree manslaughter. And the top charge, the most serious charge, is 40 years in prison. That's known as felony murder. Now, I told you what Maxine Waters said.
Reform. And so, yes, I would like to see the bill in Congress pass on police reform, but I know that the right wing, the racists, are opposed to it.
The right wing, the racist. So if you are a right-winger, you are by definition racist.
What should protesters do?
Well, we got to stay on the street, and we've got to get more active. We've got to get more confrontational. We've got to make sure that they know that we mean business.
Now, this is what this congressperson almost did. She almost caused a mistrial. The defense has argued from the very beginning that the jury should be sequestered as it was during the O.J. Simpson case. It is not. And the jury is always given an instruction to not watch the news. And the defense argued it's awfully difficult not to watch the news when it's infused, and when somebody like Maxine Waters makes the allegation that she just now made. The defense argued that it's awfully difficult to realistically expect the jury not to have heard this. And they made a motion for a mistrial, and the judge, Peter Cahill, ruled on that motion.
During the course of this trial, I've received literally thousands and thousands and thousands.
This is the defense.
Of
Eric Nelson.
Emails. So much so that I don't even look at that particular email anymore. So, but my phone gives me alerts on things that just happened. I mean, you can't avoid it. And it is so pervasive that it is, I just don't know how this jury, it can really be said to be that they are free from the taint of this. And now that we have U.S. representatives threatening acts of violence in relation to this specific case, it's mind-boggling to me, Judge.
Well, I'll give you that Congresswoman Waters may have given you something on appeal.
I will give you, Congresswoman Waters may have given you something on appeal, meaning in the event that Derek Chauvin is convicted, one of the grounds for reversal will be public notoriety and sentiment stirred up by the likes of Maxine Waters.
It's mind-boggling to me, Judge.
Well, I'll give you that Congresswoman Waters may have given you something on appeal that may result in this whole trial being overturned. But what's the state's position?
Your Honor, the state's position, first and foremost, and this is a concern I raised at the beginning of the proceedings, well into jury selection, is that we can't allow statements like this, vague statements, to be considered a part of the record on appeal. If there's a specific statement that a specific U.S. representative made, then there needs to be some sort of formal offer of proof with the exact quotes of the exact statement or some kind of a declaration. And I'm sure Mr. Nelson can do that if he thinks that that's something that's appropriate. I don't know that this particular representative made a specified threat of violence. I don't know what the context of the statement is. I also don't know what television shows Mr. Nelson is referring to in terms of any of this. And so I just don't think that we can muddy the record with vague allegations as to things that have happened without very specific evidence that's being offered before the court. As a practical matter, through the jury selection process, the court has provided instructions, has determined whether or not there are any outside influences. The law presumes that the jury follows the judge's instructions, and the court has instructed the jury today that they're not to let any outside influences or public opinion sway their deliberation. And the law presumes that they would be capable of doing that. And so without any sort of specific offer of proof or information in the record, without any specific evidence that this particular jury was influenced in any particular way, I believe that the defendant's motion should be denied.
And Your Honor, I make my comments I mean, in the context of this is all such an evolving situation. Obviously, I spend my weekend preparing for closing remarks, and I certainly can supplement the record with news articles. I can supplement the record with the storylines of the particular shows that were brought to my attention. So I'm making it to note the record at this particular point, and I can certainly supplement them.
Yeah, you can supplement the record with whatever media reports. I'm aware of the media reports. I'm aware that Congresswoman Waters was talking specifically about this trial and about the unacceptability of anything less than a murder conviction, and talk about being confrontational. But you can submit the press articles about that. This goes back to what I've been saying from the beginning. I wish elected officials would stop talking about this case, especially in a manner that is disrespectful to the rule of law and to the judicial branch and our function. I think if they want to give their opinions, they should do so in a respectful and in a manner that is consistent with their oath to the Constitution, to respect a co-equal branch of government. Their failure to do so, I think, is abhorrent, but I don't think it has prejudiced us with additional material that would prejudice this jury. They have been told not to watch the news. I trust they are following those instructions, and that there is not in any way a prejudice to the defendant beyond the articles that we're talking specifically about the facts of this case. A congresswoman's opinion really doesn't matter a whole lot. Anyway, so motion for mistrial is denied.
Wow. He said that Congressman Waters may have given you grounds for appeal in the event that your client gets convicted. Well done, Maxine Waters. Again, he faces 3 counts: second-degree murder, third-degree murder, and second-degree manslaughter. And later on, we're going to play you excerpts from the closing arguments from the prosecution and from the defense. Top charge, 40 years in prison, known as felony murder. Third-degree murder charge also. And then there's a second-degree manslaughter charge. We'll talk about that later on.